question was the definition of concealed carry and really focusing on mostly concealed, because the law says that the weapon needs to be concealed or mostly concealed. I think the importance of that part of the statute is to point out that Illinois is not an open carry law, state. In other words, the weapon is not meant to be carried out in the clear open. It is designed for the weapon is meant to be concealed, recognizing that sometimes that's an imperfect process. The intent of the individual to conceal the weapon or mostly conceal the weapon is what's focused on. I share with Professor Cain that I am unaware of any litigation on that particular issue. I surmise that it will become very fact-specific as it is employed. In other words, what was the person's intent? What was going on? How was the weapon being carried? How was it being concealed? Is something that the Office of the State's Attorney and law enforcement will focus on when trying to decide whether somebody is complying with that portion of the statute. What is important to myself as State's Attorney is whether or not an individual is avoiding open carry because Illinois is not an open carry state.
What was the rationale for prohibiting open carry? And it seems to me if one of the arguments for concealed carry is that it's a deterrent to criminals because they don't know if a potential victim is armed or not, wouldn't they be more deterred if they saw that the person was carrying a weapon? That come up?
In the course, so the question is why not open carry? Why concealed carry? My recollection is during the course of the debate, the focus was always on concealed carry. I don't believe open carry came up. I was not part of all of the negotiations. It was a push for a concealed carry.
Yeah. Are there a number of states that permit open carry?
Yes.
Yes, there are. Yeah, there are some states that do permit open carry. To respond to Justice Doyle's question, I have no opposition to open carry. I think he raises a valid point. If we're going to allow individuals to carry weapons, concealed carry versus open carry, if it's going to be a deterrent, why not allow the open carry versus concealed carry, or allow the citizen to make a choice. Probably the only thing I can think of, and I'm only thinking logically, is that the access to the weapon by somebody might be a concern. In other words, if somebody can see the weapon, it might be easier for them to disarm you at a moment when you're not paying close attention. Dismissing that, I don't see a significant difference between open carry versus concealed carry when you're talking about an individual who's trained and capable of handling a weapon, and if you're talking about wanting to accomplish the goal of deterrence. Now, with that said, the state legislature has debated it. They have decided that Illinois will be a concealed carry state, so we will move forward in implementing and following the legislature's intent, and we will operate as a concealed carry state.
Apparently, a person who is armed, concealed, can enter a business, but if that business is one that sells alcoholic beverages, and 50% of the business is the sale of alcoholic beverages, how does the person who's carrying the gun going into such a place know that? Or maybe it's a strict liability thing, I don't know.
Well, it's a prohibited place by statute. It's it's more than 50% of revenue from sales of alcohol. I think to some extent it's common sense. If you go into an establishment that is advertised as a bar or a tavern, it's more than likely going to be 50% or more revenue from alcohol sales. If you go into an establishment that is generally advertised as a restaurant, then it's much more likely you're not going to have that 50% of alcohol sales. So, you know, if I'm going out to get food and I go into IHOP, I'm not going to worry about whether they sell alcohol or not. If I go into, you know, Joe's Tavern to get a hamburger, and I have a concealed carry, I should think twice about whether I should be walking in here.
As I read the statute, a great deal of onus is placed upon the owner of the establishment to determine whether or not 50% of their business or more is the result of alcohol sales, and that they would have to appropriately post their property in that regard. There is a penalty for owners of businesses who fail to properly establish that their business is 50% more alcohol sales than food sales. So I think a lot of responsibility is placed upon the owner of the establishment to follow the law, and there will be penalties associated with those that don't appropriately do so. And obviously that monitoring is going to have to be done in conjunction with law enforcement, taking a look at businesses much along the line that Professor Cain has outlined, businesses that have questions as to how they are selling them, their products to the public, how they are holding themselves out to the public, and whether or not they can adequately demonstrate that if they are allowing concealed carry, they do in fact have sales of less than 50% distributed towards alcohol, with obviously the consequences associated in the statute being what will happen to them if they fail to properly comply.
Might make an interesting trial.
It would make for a very interesting trial. I agree with Justice Doyle, because again, it would become very fact specific as to what constitutes sales and what constitutes that 50% mark. But a lot of focus will be on these businesses, and I would imagine that liquor licenses are extremely important to them. Liquor licenses are monitored locally, and if you are now going to start violating laws that have been established with regards to gun regulation, or whether or not a gun can be allowed into a business, then you are probably putting your liquor license at jeopardy. So I think that's a pretty strong deterrent and a pretty strong encouragement for individuals to take a look at the gun legislation and follow it.
Is there anything in the law that permits law enforcement officers to declare a gun-free area? In other words, you know, what if you have a public official, maybe the President of the United States is in town and making a speech in a public area? Can Secret Service, for example, provide that no guns are within 100 yards of the President?
Well, there is a provision. One of the prohibited places are permitted public gatherings, such as festivals or parades. I would think, you know, if you have a dignitary such as the President of the United States visiting, it would fall under that provision as a public gathering and would be prohibited.
I think it's an interesting question, because I think a lot of it is born on where that dignitary is going to be. And I think the bigger question or concern, and Professor Cain is correct, there are a number of public locations that are prohibited from having concealed carry, but what occurs when we put the dignitary in a location that is clearly allows concealed carry? And I think your question is, can that area automatically become a gun-free zone? I certainly would stand corrected if somebody like this, but I don't see a provision that would allow that to happen outside of the fact that the owner of a particular property has the right to declare the property to be a gun-free zone, and if they were cooperative, perhaps they could do so, but I don't know that the Secret Service might be able to do so on their own.
Not aware of any federal law about this.
No. My guess is that the Secret Service and the handlers of the president, without having proper concessions or safety concerns, would probably more likely alter the itinerary rather than try to work within the law itself.
Well, what about this business of posting a business as a gun-free business? Do you have any recommendations if you're a business owner? What do you do? It seems like you're damned if you do and damned if you don't. There's a possibility of liability sometimes. It comes into play. Mark, if you have something.
Yeah, I was going to say, if a business decides that they do not want to allow firearms in that business, they should post that sign. It's available through state police.
Is that 4 by 6 inches?
Yes.
How do they come up with 4 by 6 inches? It's a legislature.
Yeah. Okay. I actually think it's the same size as other states have used. A lot of the law was based on what other states have done for the purpose of passing the legal challenge. The liability point, I think, as Professor Cain has pointed out regularly, will be an opportunity for the lawyers to do their thing.
I don't have a particular recommendation for business owners as to whether they should or shouldn't post it. I think that probably what will occur is there will be an analysis of their clientele to determine where their comfort lies. I believe that Illinois has embraced the concealed carry law, and my hopes is that outside of what the state legislature has already decided shall be prohibited areas, that the rest of the community allow the citizens to make their choices as to whether or not they're going to conceal carry, and allow them to move about the public freely as the statute has set up. But I believe ultimately businesses are going to have to take a look at who their clientele is and make it an intelligent business decision as they see fit for themselves.
I was just looking at the exact language of the statute. It says the owner of private real property of any type may prohibit the carrying of concealed firearms on the property under his or her control. The owner must post a sign in accordance with subsection D of the section indicating that firearms are prohibited on the property unless the property is a private residence. Subsection D says signs stating that the carrying of firearms is prohibited shall be clearly and conspicuously posted at the entrance of a building, premises, or real property specified in this section as a prohibited area unless the building, premises is a private residence. So that gets into the very issues that Mark was bringing up about, how many entrances have to be posted if there are multiple entrances? Is it just the main entrance, or is it the side entrance, or so it brings up a lot of issues that are either going to get resolved through regulations that fine-tune the statute when the Illinois Administrative Code regulations come out, or it's going to get resolved through litigation, because that's what the courts do. They interpret statutory language.
Well, by my watch, we have about 4 minutes left, so why don't you just divide it up any way you'd like and fill in anything that you may have wanted to say.
This is, as you can tell, a complex law. It's going to take years to fully understand exactly what the legislature has enacted. A lot of that will probably happen through the courts as cases are brought, challenging language and what it means in certain fact circumstances. This is how we figure things out through the legislative and judicial process. And you know, it's not going to happen overnight. It's going to take years of litigation to resolve these issues. As issues come up, I would expect to see amendments to the legislation to help fix some of these issues that maybe were not realized when the legislation was passed this past July.
My outlook as we move forward with implementation is very positive. And I rely on what has gone on in the other 49 states. I believe that they have sufficiently, within their own legislatures, made good, solid decisions for their citizens. Some states are unrestricted with regards to carrying a concealed weapon. Some states, like Illinois, and most of them are what they call shall issue states. If you meet the permitting process, you shall receive a permit. Some states are may issue. There are no issue states, but there are some provinces of the United States that do use the no issue provision. But each jurisdiction has successfully implemented this law. Each of the 49 states have implemented a concealed carry law or an open carry law, in my opinion, successfully. There is no reason to believe that Illinois will not be able to do so as well. I believe that the citizens of this community have demonstrated to me that responsible firearm owners will be responsible concealed carry permit holders. So my outlook is positive going forward.
Mark, anything else?
I would just say, I think to both of their points, it's a law that will continue to evolve over time, and I think people need to be cognizant of those concerns and make sure that they're addressed moving forward.
Well, I think we should thank this panel and thank the League and the YWCA for doing this. I think it's been very worthwhile. Thank you.